This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's a massive blow to the federal government that's been trying to break up Meta for the last 5 years. The tech giant has won a key ruling that its acquisitions of Instagram and WhatsApp didn't violate U.S. antitrust law. D.C. federal judge James Boasberg said the Federal Trade Commission had to show that Meta continues to hold monopoly power in social networking now, and that it had failed to do so. My guest is antitrust expert Harry First, a professor at NYU Law School. Harry, how big a blow is this to the FTC?
Well, it's a blow, all right. So this is the first big loss in these high-tech platform cases. So two of them have now come to a conclusion of the trial, both against Google, both successful for the Justice Department. Remedy, another story maybe. So this is the third. There are 5 total, and it's the first loss. It's sort of not a surprising loss because this judge has been skeptical of this case clearly from the very beginning. He had dismissed it originally. So he's been very skeptical, and he's said it in his opinions. So this case has not been well received by the judiciary, shall we say. So it's not surprising. The opinion itself is a little surprising, but the result is not so surprising.
Why do you say the opinion is surprising?
So in 2 ways. First of all, he's taken a very novel approach to time in the opinion. So he says that the proof has to be as of the time I make my decision almost. I mean, this is an impossible standard. He said maybe they were a monopoly. Maybe this was a properly defined product market in 2020 when the suit was filed, but as time has gone by, it's not that much time. By now, it's not. And the question is not whether it was then, but whether it is now. I mean, if you take that literally, that's a completely moving standard. You could never try a case because your evidence is always outdated. I mean, it's always about the past. You can't try a case about the future. So that's a departure. He's got some legal reasoning for why he does that, but that's a serious problem, and I think it's a serious antitrust problem. So there's that part of it. The second part is this judge is very confident of his opinion. So normally a district court judge, he's got 7 things to decide in front of him, and they proceed logically. Well, if you go for this, then you're done. But if you go for this and it's okay, you go to number 2, 3, 4, 5. So he has a long trial, but he only decides the first issue. Now, normally a judge would say, okay, here's what I decide. This isn't a market. The market has to include such and such. They don't really have monopoly power. Okay, but if I'm wrong, here are the facts that I found about the conduct. And the conduct wasn't anti-competitive. So even if you had monopoly power, this was not exclusionary conduct. It wasn't anti-competitive. And so you go through all the things, because if a court of appeals disagrees with you, now what? You've got to retry the whole case? So this is a judge who thinks, no one's going to disagree with me, man. And maybe part of it is because the narrative of the case is at least potentially stronger than the market definition. So that's when, all the emails about how Mark Zuckerberg's theory was to buy them or, bury them. And, what he tried to do with competitors and why he paid so much for Instagram and for WhatsApp. WhatsApp drops out of this case like right away. I don't know, third word or something. He says at some point, we're done with them. We don't have to talk about them anymore because we don't get to them. That's not involved in the market definition. So that's pretty unusual, I think. And it's either hubris or confidence. I don't know which, but he does not do what I think most district court judges would do, which is decide the full case.
I thought the focus would be on the market when Meta bought Instagram and WhatsApp, and whether it was anti-competitive conduct when it's alleged that Meta couldn't compete with these 2 apps, and Zuckerberg said it's better to buy than compete.
Well, what he tried to say was, we've got to do it as of now in part because of the FTC's remedy powers. They're asking for an injunction, and they can only stop conduct that is illegal now. So I've got to decide what's illegal now. Now, he could have very well said, that's a remedy question. We'll decide that when we get to remedy, whether it's a continuing violation or not. We should look at whether there was a violation then. So, for example, if this were a suit for damages, you wouldn't say, well, we have to see whether there's a violation today. You would say, let's see whether there was a violation at the time that the offense was committed and what damages were caused. So those two things are separate. So it's really quite odd. And you're right. The argument that the commission makes is that we look at what they did and why they did it, that this was an effort to maintain their monopoly. These two acquisitions for which they wildly overpaid. Why were they paying $19 billion for a company that didn't have any revenue? That was WhatsApp. And the answer was they didn't want them to develop into competing social network platforms. So, now that part also had problems. It had issues. The Federal Trade Commission and its earlier guys let those acquisitions go through. So there were issues with it. But so in that sense, that's a really strange aspect.
Did the judge come to this decision because of the way he defined the market and the fact that he put YouTube and TikTok in the market?
Yeah, so the first question, and you have to show that a defendant has monopoly power in a relevant market. So he says, okay, we have to start with market definition. So that's true. That's the way it's normally done. And then he says, okay, yes, let's look at the market. And what we have to do, he basically puts in, he says these platforms have converged. These are all sort of similar. And particularly TikTok, was posing a competitive threat. He says people don't want to talk to their friends anymore. They just want unconnected videos. So, here's TikTok comes along and they're posing some threat, and Facebook responds with reels, short videos. And so that has now changed how we define the market because users switch back and forth between the two. And we have to include TikTok and we have to include YouTube, where users switch to those videos. Later, at the end of the opinion, he says, well, the argument for YouTube actually is a little thinner. But even if it's just TikTok, that's enough. We would include that in however we define the market, whatever we want to call it. He doesn't really give it a name. And at that point, if we include TikTok, then there's no monopoly power. Meta or Facebook does not have monopoly power, that TikTok takes away too much time. All those kids are frittering away their time on TikTok instead of frittering away their time on Facebook. He had various evidence of, the willingness to switch, and that people switch between those two. Normally, for looking at substitutes, you say, so if the seller raised its price, what would people switch to? Well, the thing is, Facebook doesn't have a price in that sense. What it has is ads. I don't know if you've looked at your Facebook feed recently.
I'm not on Facebook, I will confess.
I got you on that one. Yeah, well, there are a lot of ads on Facebook. And so, that's sort of the price. But the judge didn't seem to think that people minded those ads so much. They're nice ads. They don't really interfere so much. So, not so bad. And people were switching, particularly, I think, younger people were switching over to TikTok to, for whatever you get in TikTok. Now, what you don't get in TikTok particularly are friends, groups of friends. And that's what the government sort of honed in on. It's a social network. It's put together by who your friends are. And what Boasberg observes is that at least some users don't really care so much about their friends. They want to be put together more by interests. I like, knitting? Japanese cooking. So I get lots of videos about Japanese cooking. I don't know the Japanese cooks, and they're not my friends. But that's what I like to look at. Or I like recipes, that are easy to make or crazy to look at, whatever TikTok has. So people have switched to that and away from Facebook. Now, The odd thing in some ways is, if so many people are switching, how come so many people are still on Facebook? He gives 230 million U.S. users, I think is the number, and ad revenues of $161 billion. So when you read his description, it sounds like this is a company that is just in the throes of death from TikTok. And then he says, this is an amazingly successful product. Give people a compelling product for free, then sell ads that can be seen by millions. I guess he thinks those are good. 240 million active users in the United States. That's a lot of people. So apparently they haven't been dissuaded by TikTok, which is also free. And, you know, they don't give all their time there. They're still on Facebook. So the argument, presumably from the government, is that by incorporating Reels, they've managed to defend their core business. And their core business is social network, putting people together. And they still get a lot of people who like that product, even though some people also use different products.
Coming up next, I'll continue this conversation with Professor Harry First of NYU Law School. Will the government appeal the decision? I'm June Grasso, and you're listening to Bloomberg. Meta prevailed over an existential challenge to its business that could have forced the tech giant to spin off Instagram and WhatsApp. In a loss for the FTC, a judge ruled that the company doesn't hold a monopoly in social networking. I've been talking to NYU Law School Professor Harry First. Harry, here's what an FTC spokesperson said about the loss to Meta. We're deeply disappointed in this decision, but the deck was always stacked against us because of the judge. Boasberg has ruled against the Trump administration in some high-profile cases this year, and he's also been frequently criticized by the president and the attorney general. This just continues the Justice Department's attacks on judges.
I hadn't read that, and you sort of wish that they hadn't done that. Yes, Judge Boasberg did stand up to the Trump administration, and Trump singled him out as, I forget what description.
Crazy, lunatic, something.
Lunatic judge. So now I don't know which way it even goes, particularly given the fact that there was a report of Mark Zuckerberg meeting with Trump in the Oval Office to settle this case. And Trump was dissuaded, apparently, from settlement by the efforts not so much of the chair of the Federal Trade Commission, but by the head of the Justice Department Antitrust Division, Gail Slater. So maybe the FTC should have settled it then. Maybe they would have done better. But it's just, first of all, it's in some ways so wrong because Boasberg took this position way before the immigration cases came up. From the beginning, when he dismissed the complaint, the original complaint, and let them refile it, he's been critical of this case. So to see this as a connection of, you know, some crazed judge who is just against the government? I mean, it's just wrong. I wish they'd stick to the problem that they've got, which is that this is bad law for the FTC and for antitrust enforcement. And, you know, now we're going to see what they're going to do about it. Are they going to appeal this decision or not?
Yeah, so that was my next question. I mean, it sounds like they should appeal because of the timeline that he's defining markets on. But might they not? I mean, Zuckerberg has been courting Trump for quite some time.
It's hard to assess the political wins because conservatives had been upset with Facebook, thinking that their algorithm has, you know, discriminated against them. I sent an email to my niece last night who uses Facebook all the time, and she says she thinks they don't post any of her left-leaning posts. They don't seem to get moved up into the feed, but, you know, the calm ones do. I don't know.
I like that you're doing research at night.
That's research. That's my empirical research.
Fair enough. Although Zuckerberg seems to have tried to turn that around by weakening hate speech policies and eliminating fact-checking.
My view of Mark Zuckerberg, he hasn't turned at all, is that he just turns whichever way the politics are. So now it's this way, and that's fine with him too, as long as he keeps, you know, their apparently the third largest digital advertiser after Google and Amazon. So they're doing really, really well, despite Boasberg's feeling that nobody wants to talk to their friends. Apparently a lot of people still do, and they read those ads and click on them.
If this were an administration that just based its decisions on the law, would they appeal to try to get this ruling that the government has to show monopoly power now reversed? Or because of Zuckerberg's attempts to court Trump, do you think they might not appeal?
Who knows exactly which wins? And the wins may go the other way because, a populist wing of the party feels that these platforms have too much power and need to be cut down. So who knows exactly? But if you look straight at the legal issues, usually appeals from adverse decisions of trial courts are hard to win on appeal because they're mostly fact-based. So you have to look for legal issues. And there's an important legal issue of, whether he applied the correct standard for defining the market and for assessing when a violation occurred. And that one's sort of a very pointed legal issue. How it will fare in the Court of Appeals if they do take it, I don't know.
And does this decision have any implications for the other antitrust cases against tech platforms?
Yeah, that's a good question. Perhaps. I'm thinking of Amazon, for example. And these are platform cases. And platform strategy is you have a core product, and what you want to do is to keep people on the platform and engaged because of the strength of the core product. And you defend the core product by acquiring things around the periphery that might challenge it, or by doing things. These companies are always subject to some competitive forces, even if they're monopolists. So certainly Facebook was. TikTok did pose a competitive threat. And Amazon similarly has competitive threats to which they respond. But the basic strategy is pretty similar. And the market definition in some ways is similar because they offer a bunch of different products in the same place, much as supermarkets do, like Whole Foods, for example. So you have a, sort of core product and then other things that they offer that other firms may compete on. I mean, look at your smartphone. So 35 millimeter cameras compete on cameras, but, are they in the same market? No. So you could say this is quite similar. Yes, TikTok competes. I'm surprised Twitter's not mentioned. Twitter competes, to some extent. But these are all to some extent. And it's still Meta defending its core product in which it has a lot of power, as all advertisers know.
Always a pleasure. Thanks so much, Harry. That's Professor Harry First of NYU Law School. Texas kicked off the nationwide redistricting battle, but now a federal court has blocked the state from using a redrawn congressional map that was engineered to give Republicans 5 additional House seats. The ruling is a blow to President Trump's efforts to preserve a slim Republican majority ahead of the 2026 elections. Joining me is elections law expert Richard Briffault, a professor at Columbia Law School. Rich, so this was a 2-1 decision. Will you explain why the judges decided that Texas couldn't use its new congressional plan?
In a nutshell, the court concluded that this was a racial gerrymander and not a partisan gerrymander. And as you know, the Supreme Court has said partisan gerrymanders are not unconstitutional. There's no basis for challenging them in federal court. But racial gerrymanders can be unconstitutional and can be challenged in federal court. So the heart of the court's decision was that this was a racial gerrymander. And what did they base that on? The court said what triggered this, although we think of this as Trump demanding more Republican seats from the Texas congressional delegation, in the court's view, the Texas governor was initially reluctant to call the special section to create the map until he got a letter from the Department of Justice in Washington that said several of the Texas districts were unconstitutionally created on racial grounds. In particular, the Department of Justice focused on so-called coalition districts, which are districts which are majority minority, but not one particular minority group. And for a period of time in the Fifth Circuit, courts there had said that the Voting Rights Act could be interpreted to require the so-called coalition district, which, let's say, is 40% black and 30% Hispanic. Neither one is a majority, but together they add up to 70%. And so the Department of Justice says, well, we see 4 districts in your 2021 map that look like they're coalition districts to us. And based on a recent decision in the Fifth Circuit, we think that makes them unconstitutional. So you got to fix it. You've got to redo those districts. So what the 3-judge panel in this case concluded is that that was what was driving the redistricting. They looked at the statements of the Governor Abbott, and of the leading members of the state legislature. And they also looked at the resulting map. And they pointed out that most of the changes in the redrawn districts went from being so-called coalition districts to districts in which one race or another had a majority, and often an extremely narrow majority. They said there were 3 districts. They were either black or Hispanic, where the majority group had like 15.2%. So they said the combination of the Department of Justice letter, the governor's statement calling the legislature into session, and statements by many of the leading members of the legislature, and then the districts that were created, in their minds, this meant that race predominated. The desire to create racial majority districts is what was driving this. It's true, the court said it also clearly had partisan consequences, and there may have been some partisan motivation as well. But they said the dominant motive that they found was race, and therefore this made it an unconstitutional racial gerrymander.
Even though we know that the reason that Greg Abbott called the special session was because President Donald Trump told him that he wanted to get, extra seats in Texas?
I think what you could say is that, to borrow from Shakespeare, the Department of Justice was hoisted by its own petard. I think when this all began, it's now like 4 months later. It's amazing how much has gone in 4 or 5 months. When this all began, maybe people thought it was too blatant to say this was all for partisan reasons. I mean, we've now been totally partisan since June of this year in the redistricting. But maybe they thought it was just too blatant to say we're doing it for partisan purposes. So the Department of Justice trumped up this racial argument. There was no argument, actually, that those coalition districts were unconstitutional. You could argue that there's no mandate that a state create them, and that's certainly true now. But there was no evidence that they were unconstitutionally drawn. Nonetheless, Department of Justice having, I think, provided this kind of pretext for the state to go ahead and do the partisan gerrymander, but given that that was the stated reason, the court was able to say, we think it's a racial gerrymander. They also made the point that the Democratic districts which were undone mostly fell into this category of coalition districts. And they pointed out there was one white majority Democratic district which was barely touched. So they do have some evidence suggesting that most of the focus of the legislature was on coalition districts and making them majority one race or the other. But I think what you've got here is this irony that at least in June of this year, the governor and the Department of Justice thought it's too blatant to do it for purely partisan reasons. So we're going to give them an anti-race discrimination motivation. And that has, I think, turned around to sort of bite them in the rear, at least for now.
And now the question is, what will happen when this gets to the Supreme Court? Rich, we've talked before about the case currently before the Supreme Court on the Louisiana maps. Does that fit in anywhere here?
Well, here I think what the court, 3-judge panel, really 2 judges, there's a dissenter. The majority opinion is 160 pages long. But I think the court said here, yes, the issue is sort of disentangling race from party. Again, to restate, racial gerrymandering is unconstitutional, partisan is not. The court just kind of went through a lot of evidence and said, we have all this evidence. And we think it shows that on balance, given the governor's statements, given the statement of the chair of the relevant committee, given the statements of some other prominent legislators, and then given the results, we think this is predominantly racial. And therefore, it violates a pre-existing doctrine. The Louisiana case turns on whether or not, in fact, it was predominantly racial to create a second black majority district. But here, this was really about, you had a valid plan in existence before, and this is whether or not were the changes predominantly race-based or predominantly partisan. And the court says, our view of the evidence is that they're so predominantly race-based, we think a preliminary injunction should be granted.
They're appealing right to the Supreme Court. First of all, I mean, as far as timing is concerned, there's a December 8th state deadline for candidates to file campaign paperwork. Is the Supreme Court likely to make a decision here within that time frame?
Well, I think the real question is, will the Supreme Court say that the lower court has made this decision too close to the election? There's this doctrine called the Purcell principle, based on a Supreme Court decision now about 25 years old, in which the court says that federal courts should not undo state election laws if they're too close to an election. The court has never said what is too close to an election, but there have been some orders from the Supreme Court in recent years that treated decisions that were within 6 months of an election as too close to an election. And the Texas primary is in March. So looking at some recent Supreme Court decisions, there is a plausible argument that this court's decision is too close to the election and therefore should be stayed. Now, the court addresses that for about 20 pages, and they make the point that the Texas plan was not signed into law until the end of August. And if you took the idea that 6 months is too late, it was almost too late as of the moment the Texas redistricting was signed into law. It would have been impossible to have a challenge, have the parties do the research, have a hearing and have a decision in time to take something like 6 months. So the court makes, kind of a strong pitch for saying that the Purcell principle has to be handled flexibly. We've got to look at how late the Texas legislature did this. And we do have to say that it is possible to come into compliance. They make two more points. One is that the old map is still in existence because Texas is about to hold an election on that old map in January, because there is a vacancy. A member of the Texas congressional delegation died early this year. There was just a primary, I think, to fill that. The general election to actually fill that seat won't be until January. That's on the old map, the pre-gerrymander map. And so the court says, well, the old maps are still the law. So under our preliminary injunction, we're just going to continue to live by the old map. So the old map is still on the books. And so they're saying that in some sense, the real disruption was the state legislatures acting so late. And so therefore, we should be able to do this. And yes, it's still time for everyone to come into compliance to file under the old maps. I think the first question, maybe the stronger argument, when Texas appeals this to the Supreme Court, I suspect they will lean heavily on this Purcell idea that it's too late, that we're about 3 weeks away from the filing deadlines for the March primary, and it's too late. And I think secondarily, they'll say, well, yes, there is a lot of race evidence, but there's also partisan evidence, and we should defer to the legislature on that. So I think that's how that's likely to go. What the Supreme Court will do is unclear, but there is a plausible Purcell argument that it's too late. But as I said, the court is very strong in saying, well, if that's the case, you can never bring a challenge to a gerrymander. That indeed it's an incentive to do the gerrymanders closer and closer to the election to make it impossible to bring challenges.
If the Supreme Court says, forget the Purcell principle here, how do you think they would rule on Texas's appeal, that this was a partisan, not a racial gerrymander? Do you have any idea on that?
It's really hard to say. I mean, I think I think the court acknowledges that there's evidence on the other side, but they have, in particular, the testimony of the map drawer, the Republican specialist who was hired to draw the map, who said, no, I never looked at race data. The court said, we essentially don't believe you, partly because there were discrepancies between your testimony and the testimony of the state legislator who hired you, but also because we just don't believe that you could produce 3 districts that are 50.2, 50.3, 50.4% majority. I think 2 were Hispanic, 1 was black. I'm not sure about that. And that's so precise, and you could do it 3 times, and that you were not paying attention to race. But there is counter evidence. In theory, the Supreme Court's not supposed to judge the evidence. That's really for the lower court. They're supposed to defer to lower courts on evidentiary findings, but the current Supreme Court has not always followed that rule. So it's hard to tell what they're going to do. And we haven't seen the dissenting opinion, which may provide, good arguments for for Texas when it takes this to the Supreme Court.
As you know, this whole national redistricting battle was started by President Trump. And California has approved a redistricting plan that would offset the Texas map, which is now in serious jeopardy. Tell us about the legal challenge to California's redistricting from California Republicans and also now the Trump administration.
I mean, they're basically making the same argument that prevailed here, that this is a racial gerrymander. I mean, they can't bring a partisan gerrymander argument because, as I said, the Supreme Court in the Rucho case in, I think, 2019 said those are simply not justiciable. You can't challenge. So I think they're bringing a claim that the legislature's motivation was race. Presumably they've targeted specific districts for that, but I don't know what they've argued in that. But I think the essence of it is that it's a racial gerrymander. It's very similar to the argument. I don't know the details, but the basic idea is similar to the argument that the three-judge court in Texas recognized in striking down the Texas gerrymander.
And it's sort of opposite of what happened in Texas. The Justice Department argued that California's map illegally bolsters the voting power of Hispanics in the state.
Yeah, which is interesting because, of course, in Texas, one of the arguments Governor Abbott made is that this is going to actually strengthen the voting power of Hispanics. Although he combined that, he was basically Hispanics are becoming more Republican, and this is going to allow them to be able to articulate that in districts, to vote their preference in districts. He had a kind of a sentence which kind of combined the two in one sentence. But yes, so, I mean, much would turn on whatever evidence they have for that. There's also an argument that there's been a lot of debate about this amongst the law professors in the last 24 hours as to what's the significance of the fact that the California redistricting was approved by the voters. Would the challengers have to prove that the voters were racially motivated as opposed to the legislature? And I think up for grabs because the public campaigning was largely on party grounds. So whether or not, even if there was a racial motivation within the legislature, whether that was some kind of washed away by the voters, or whether if it really is racially tainted, whether the legislature's motivation was racial, pro-Hispanic, whether it doesn't matter that the voters voted for it because they thought they were voting on partisan grounds.
That's interesting.
So that will be an interesting fight.
You law professors have some interesting conversations.
Yeah, obviously it's been all online, but it's been an interesting back and forth on that. Of course, the government and the plaintiffs first have to show that the plan was racially motivated and not partisanly motivated, even within the legislature. And then if they conclude that it was partisan even in the legislature, then the effect of the voters becomes irrelevant.
And there are other states, both Democratic and Republican, that are in play. We'll see what settles out. Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.